some of the cases which I have recently get involved. So at least I can give you a feel of how a judgment relating to this subject will appear to be. This is basically the way I do my research in the daily practice. So you want to get involved in a more sophisticated level, so you need to know the update position. So you go to advanced search. So basically the easiest way, like for instance, if you want to get something about probate action, so you do a wild search, so you get various cases that is involved in this subject, and you try to get in additional stuff which you may like to narrow down on the various subjects. So, like caveat, so you narrow it down. Oh, then you can see the various cases that are involved in this area. The way I do it is, if I'm very serious about a research, then I'll try to sort by relevance. I'll sort by relevance. But then if I want to know the update trend, then I'll sort by date. So these are the various cases. So this is how you can get involved. Now, the recent case which I have done is I go parties of representation. Usually start with the firm or the counsel. So this is the name of a legal firm. So you want to get involved. Let's see what have been done in the past. So these are the various cases which I have handled. And about 90% of them are relating to this particular subject. So you can see there is one here in this year, and then if you go all the way back down, you can see go to 5. So the earliest reported cases I got involved is 1989 on this subject. So that is the case. I started my practice for about 2 years. So you go all the way, you check it out. This is the first case that I handle. And it's interesting to see how one develops. And then you may even go to, sometimes we instruct counsel to do it, and sometimes you do it yourself. How can a solicitor deal with this? There are different scenarios that you can get. Either you on a representation basis, or you've got some kind of appointment that you've got the capacity. So this is my name according to my ID. So check it out. Right. So basically, there are 2 reported cases discussed this year, done by me, and one is just this month, and the other is in August. So, for instance, you can see this is the case we're involved in all this. a lot of contention. This case is interesting because this case is concerning about the making of a will, and exactly I was the solicitor involved in the preparation and the attesting the execution of the will. So that was about 2008, and then this case has been subject to a lot of litigation in the past 15 years. So you can see they fight and fight and fight. No. Here, my firm is named as like a defendant because they want to get some information from us in order to deal with the fact that how the will was prepared, how the instruction was given. So that will be something that we'll teach about on the making of will in this subject. In lecture 4, that will be kind of relevant. So what I did was I prepared a will, and then there are all kinds of steps that you have to be careful concerning to know, as we have discussed briefly last time, about the way to prepare a case, get instruction from your client, and then explain to the client, and then get proper attestation witnesses, and that's all you have to go through. Now, the process is not difficult. The only difficult part is when you are getting a will for someone who has only about, let's say, 10,000 cash as all he owns, then it's no problem. This is a small potato. But then in Hong Kong, we got all kinds of multimillionaires. They got tons of money. Then they will. What they will say is that they will leave no stones unturned. They try to get all kinds of information in order to see if there is anything that they can attack in order to affect the validity of the will. So that is something interesting because you guys are just like newborn baby. You're on your way to get it. And then the other thing is you don't know the problem. Think everything is so easy. So only wait until the days when you get your fingers burned. Then you know, when I look back, I have to be very careful. Otherwise, I wish I had never done that. So that is something interesting. Now, the other case which I recently done is this one, just last week. So again, this is another case. This case is interesting because we're talking about appointment of executor. That will be number 7 or number 8 lectures. We're talking about people who die, leaving a testate and intestate, and then how you apply for a personal representative, whether by way of direct general entitlement or by way of some other entitlement, which we'll discuss. So in this case, so there is this beneficiary suing the estate, and then that's what they have done. So they sue the personal representative. Eventually, it's taken quite a number of years. This case is interesting and is involved in lecture 5, where we'll be talking about all these intestacy, so to speak, the rule of intestacy. Except that this is a little bit more difficult because it goes about the Chinese customary law, which is a very weird subject, applied mostly to the new territories, the land in the new territories. So again, there's all this fight. Now you see, there's what they call, I got involved because I was appointed as, when the original personal representative died, the estate not just administered, not just finished. So what they have done is they have to appoint what we call a secondary board in order to complete the estate. So that's why I was involved and being chosen by both parties, and then I'm an independent third party to come in. So I become what they call an administrator de bonus non. So it's a funny term. We've got all kinds of Latin. But then it's no more than just an unadministered, incompleted estate. and getting on the second round when a grant is issued. So I got involved. And then all the way down, you look at it. So various pieces of land in the new territories, different types of ownership, some by way of Jiutong, some by way of inheritance from the parents, some owned by the deceased himself. So it creates a very complicated situation in terms of who is entitled to what. Some of them is entitled to what we talk about under in lecture 5 on the rule of intestacy. So because there are some land which has been resumed, meaning money has been paid and some cash is spent. On the other hand, there is a very narrow argument in this case. Whether land inherited shall be inherited by only the male descendant or by the female as well. So this is one of the rare cases that the judge was able to take a look at all this. So this is what it is. It looks very complicated because of so many different lots of property. Now I got involved here, so I appear as a substitute position. I substitute because the original personal representative died. So I get a new capacity as a new administrator coming into being. Then in order to get into all this entitlement of inheritance, so I look at the various legal point. I find that the legal issue is point is very narrow. This point is very narrow, except that it's up to the judge to see whether an unmarried daughter is entitled to inherit. So this is an extremely rare species of a point of law that one will get involved. So we will talk about in Qing law where an unmarried daughter is entitled to maintenance, and then when she eventually gets married, she is entitled to dowry. So all these things probably in your career, most of them will not get you involved. But then, particularly for those of you who have the opportunity to work in the new territories or work with those conveyancing firms, then somehow you may have the opportunity to get involved with all this land, the new territories. So that is something. So I decided that in order to conserve money, I can do it in my own capacity without retaining counsel. So that's exactly how I got involved. And then the reason why I want to show you this is I was like you guys, except that I'm older by 4 decades. I try to accumulate the expertise. So you guys are exactly what I was 40 years ago. 40 years ago, I picked up from nowhere. Eventually, bit by bit, it's like a trial and error cases, then you establish your expertise. And that, I want to show this to you because I'm still able to do it, and argue among counsel as a solicitor only. In this kind of cases, it's possible. That's why in the first lecture, as I've told the class, you guys, as long as you've got a mind which is steady, and you're able to under the facts very, what we call systematically, then the law is not difficult. You need a sharp mind, and in order to see what are the things that involved. And so sometimes you win, sometimes you lose. Okay? So this is a kind of risk that one will have to take as a legal practitioner. So you guys will also be legal practitioner, because very much in future you'll be exposed to all kinds of lonely fight, and there's no escape, and you have to do it. And so, and I'll show you something else. I show this to you Not that I want your recommendation or your business. I don't need your business. I want to show it to you just to show there's no complaint of confidentiality, because what I talk to you are all reported in public scenario by way of judgment. So that's how I can share with you, and I can criticize myself, rightly or wrongly. It doesn't really matter. I will sue myself. So I don't mind share this with you. So the kind of cases that I've done, now, this is again another case, which is reported last year. So it's kind of complicated the first time you look at it, but once you get through all this, it will become kind of user-friendly. So we talk about Order 85, which is lecture 10 on the administration of the state, and then, you know, all this. Again, there is this fight, and people would like to preserve their confidentiality, and this is a case involving better application. So, in chambers, I can also attend. So, people try to fight and ask the court to sort of settle the disputes. So this is how the court eventually will decide what needs to be done. I was lucky because I have the opportunity to work with those people who are senior counsel. So I actually, you know, learn from them. But it's interesting to get the exposure. So this is how you can get yourself into the legal profession. And that's why I say to you, class, because you guys are talents, and you have the chance to actually pick it up consider where you establish your professional expertise. Bit by bit, you'll be able to do it. My English is not very thorough. I'm born in Hong Kong. You know, you can see my English is kind of a Cantonese oriented, but it doesn't really matter. It's the law that matters. And also, you prepare the written submission. So all these are well prepared. There's no surprise. You know your legal point. So you started, you guys, with the 10 lectures that are about to start, that will lay the foundation. And then, so this is how you can get involved. And one of the most interesting cases which I've done is the Anita Muiz case. Now this is not the Anita Muiz case, this is another case close related with number 2. So it's a case of a listed company. There is a fight, you know, over disease. So they fight and they fight and fight and fight on any legal point that you can think of. They will fight. Because talking about legal fees, it's just peanuts, you know. They are talking about billions of dollars. And you are just spending about millions of dollars. So it's just, you know, nothing. So you can see the various various stages that they fight. So you can all see all this. So the other case, now this is the case that I got involved again. This is an Anita Muiz case. Eventually the case, this case is on validity of will. Now I've talked about validity of will with you guys on section 5 of section 1. Again, this is how the whole thing grows up, and it is the argument of the same legal point: formal validity, substantial validity. So eventually the case, we fought all the case all the way from court of first instance to court of appeal, and then to the court of final appeal. So all these are fairly interesting. And I look at it around this area. A similar scenario would be Linacong's case. Linacong's case again is similar fight for years, and eventually they try to get on to the court of final appeal, in order to decide. Lina Gong's case, fighting about the will of the state, of the will of her husband, Gong Jinghui, then it's all the way to the Court of Final Appeal. And then by the time when there is a fight about her own will, then the case only reached to the Court of Appeal because the law points are fairly developed. And then they say, no, there is no more need to fight the case all the way to the Court of Final Appeal. So it's a finding of facts, so to speak. That is something interesting, because this is how you can sort of develop your expertise. I share this with you because by looking at these cases, you'll be able to see my footpath. It's not easy because it's ages, it takes years to go through all this. But then if you think that you are just like me, who can establish the expertise in the legal field, you can do it similarly like me. All you need is, once you have developed all this, then all you need is a chance. All you need is a chance. Once you get into cases, then people know that you've got the talent, then you can repeat the history. So this is how you can do it. And I show all this to you just to let you know, nothing is impossible. It's not so far away. It's just all within yourself. I don't care about you in your 20s or in your 40s or 50s. In this particular area, you got all kinds of talent. So people, just sit with their mask on. You cannot even see their face, but you'll be surprised. You've got all kinds of talents, within this class. So try to pick up as much as possible from me, and as well as from your classmates. Once you get it all done, then so to speak, as they say, the sky is the limit. All right. So this is one area which I would like you to pick up. And there are cases. There are certain judgments also in Chinese. Then you have to search the Chinese and you see how one developed on the same legal theme, except that the judgment is written in Chinese. But this is even better for you guys, because the more judgments in Chinese, meaning the chance of employing your talents will be more. You cannot get a Guailong to talk about Chinese, right? So you guys can do it, and you've got all kinds of people from across the border. They are so rich. They don't care about money. They just decide to have their girlfriends and then they die here. So we've got all kinds of cases here. It will happen and happen and happen and happen again until you retire. Okay? So I just show you all this. The other thing is, sharing all this judgment is okay. You can see how the legal arguments are being developed. Instead of just reading on the textbook, you're looking at the legal point in isolation. But then with this, it's just all around us in our daily life. You can see how people would argue, and then how people would try to get involved with different kind of elements, legal points. Hong Kong is a funny place because we have statutory law, and then we also have the common law. Common law are rapidly developing. It's changing every time. So these are things that you guys, and I show you all this because this is the best way to get the expertise. Online, get the judgment, and it's entirely free of charge. So all you need is just to follow my path and see how you can establish yourself. Case number. Let me tell you how you can do it. Sometimes you don't remember the number. All right? So these are the similar points that you would like to. Sorry about this. don't need to remember number. Just try. It's always easy to use the several sorting elements in order to try to get the judgment. Like for instance, okay, this case, I say ham, may, ham. And then CFA. Always use this phrase. Then you'll be able to find the various cases instead of remembering the numbers. Sometimes you don't want to waste your time. So this is a try and error. All right? Then, no. Last time I also told the class how to do it by way of the iPhone. And then thanks for the related students who taught me. So last night, and I was trying this, and I got easy, very easy now. So I can show you how to do it. But my iPhone is out of power. Now, do you have an iPhone? Okay. So you have to. I want to go to the search area. Oh yeah, that will do. So why don't you do it for me? I'll tell you. Search. Let's say judgment, Hong Kong judgment. All right. Now, last time the lady student showed me, and I worked it out. So once you key in something, you can see this here. It's in the middle there. There's a square and then an upper arrow. See that? This is a magic. Now, oh yeah. You see this? Down below, once you use this, then you can see the add bookmark. This is the add bookmark that will enable whatever that you have chosen, that it will appear in your screen. All right, now let's do it. So I want to add, and it's done. So next time you open it, then it's at your fingertip. So try to do it two ways. One is exactly at your fingertip, and I note that there are two options. One is add bookmark. The other, I think, is on the screen or something like this. Just like you show the docs here, and I want this to come in at the front page. Favorite? Oh no, home screen. Yeah. Thank you. Yeah, thank you. Now this is it. Now one way is add bookmark. You find it? ADDBOOKMARK. Add bookmark is like the way that I did it. Okay, it takes a few keystroke more. But then the other way the latest series show me is add to home screen. See that? Add to home screen. Add to home screen will immediately appear like the various logo there, the icon there. Then next time you open it, as long as you've got enough storage space in there, then you'll be able to find it. So these are two. One is add bookmark, the other is the add to home screen. Now, this is the second best because you use it with the iPhone. Then when you're on the road, then you can always get your fingertip. Other than that, now, it is always advisable for you to get it with the notebook. Then do something similar because it's much better using the notebook because the words are bigger. And the other good thing about this is I want you guys to develop the habit how to translate all this expertise and the useful material to become your own. The best way, like if I were to quote the law either in Chinese or in English, or sometimes part of the judgment, so it's much better to use it in the notebook here, then copy and paste, and then that will change into your own script. So that is much better. This is something which I cannot do with the iPhone. But with a notebook, then with the information already on the screen, you cut and paste, and then turn it into your Word file that you can handle. Okay? So this, in terms of you need to be hand-on, and if you are in need to get all these precedents immediately, then the only way is to use the notebook in order to copy like this. And there is another function, some PDF file. You turn the PDF file into the OCR. With the OCR, you turn them into Word. So that is how you can translate all this so-called expertise, all this judgment or precedents, and copy them and become your own working material. Okay? Okay, now let's get back to where we left out. Now, last time we have in fact covered a very difficult legal concept. Very difficult. Because all along the whole 10 lectures, we will be traveling from different scenarios in terms of entitlement, meaning entitlement to get the benefit when someone dies. So this is what we call succession or inheritance. On the other hand, you will also be examined on another right, which is the right to apply for a grant. So all this will be sort of in the movement as we move along in these 10 lectures. And the most difficult part of all this 10 lectures is the legal concept that we talked about last time. Difficult in the sense, your entitlement to benefit, your entitlement to inherit. Sometimes you started off from what we call testamentary disposition, meaning in a will. So you get benefit under the will, or you get benefit by way of the relationship when there is no will, intestate, so it's a rule of intestacy, which is Cap 73. Or if none of the two works out, the only third way, in order to gain the benefit, is for what? So either testate, testamentary disposition, intestate, rule of intestacy, Cap 41, maintenance from the estate. These will be the three things that will be operating when someone dies and you want to get a share of the asset. We call the estate, one way or other. So last time is an important doctrine is how this can fail. How this can fail. If you don't have a right, if you don't have a right to inherit, then you don't have a right to apply for a grant. This is normally the case. So if you have a right and the right is being cancelled out, so you could have it, and then you lose it, then you don't have it. So that is the doctrine of lapse that we talk about. And then we also discuss the two other related legal concepts. One is ademption. Ademption is just like cancellation. So a specific gift, I give you a specific gift, and then somehow it ceases to appear when I die. So the gift is redeemed. The gift is redeemed. Then, on the other hand, we have the abatement, the doctrine of abatement. Abatement means reduction. Abatement means reduction in the sense it is still sovereign. Some estate, people die, leaving some estate, but then some part has been used up for payment of indebtedness, expenses, liabilities, so on and so forth. So we'll call them indebtedness. Now, for that, somehow has to be paid, then left behind, still sovereign, still somebody can get it, and yet there is a reduction. And then the most difficult point that we talked about last time is the failure. We said there is a lapse. Then the consequence of lapse, which is important. If you are able to understand all this, this most difficult legal concept in a whole module, then you should have no problem moving on. Because the others would be like rules and precedents. They are not, strictly speaking, not law. They are practice, they are rules. But what we talked about last time, that is a several sets of very difficult legal doctrine. And once you get attuned to it and you have no problem understanding, then later on, when additional legal doctrines are being built into your understanding, you will have less problem. In that sense, because we got lots of, all this what we call the equitable doctrine, and that will find its way into trust. Not express trust, but trust. And then we will have what we call, is trust implied by law or some kind of agreement that changed the ownership, which is, as I've told the class on estoppel. Trust, we have constructive trust, not formal trust, but it's a legal concept against a legal doctrine. I say it's very difficult to understand when you start off. But if you accepted that this is a kind of legal doctrine, then if you are able to understand what we discussed last time, because we have opened up the door on legal doctrines, all you need to pick up is additional doctrines. Then your future road will be wide open, including what we talk about estoppel or bona vacantia and donation mortis causa and all this. It may find it difficult, but they are all part and parcel of related legal doctrines that will come around in this area. Okay? So last time, let's get back to the lapse. So we say we quoted there are 4 examples of lapse. And then the consequence of lapse, which is important, if you are with us, is on the failure of different types of gift. Remember, this was most time consuming, and then some of us may not be able to follow. Let me repeat. Now, is the failure of the gift, meaning is the doctrine of lapse. Lapse caused the gift to fail, and then if the gift fails, then what is the consequence? This will be the kind of question that you have to address yourself. So the easiest thing, always remember 2 types of gifts only. Got it? One is the residual gift. Maybe a slight variable under 3 different circumstances on testate, intestate, and gap 41. But residual estate, that is the thing that we must remember. question is it or is it not a residual estate? That will be the initial question that you must ask yourself. All right? If the answer to this question is in the negative, so this is not residual estate, that means this is non-residual estate. This is non-residual estate. If this is non-residual estate, we say, okay, it fails. Lapse. The doctrine of lapse kicks in. So it's a failure of non-residual gift, then the failed part becomes part of the residual gift, and then will be taken by the residual beneficiary. All right? Once you understand this concept clearly enough, together with the other consequence is the failure of the residual gift. Now there may be total failure of residual gift. There may be partial failure of residual gift. So this is the failure of the residual gift, let's say in a testic situation. In a testic situation, residual gift is the ultimate kind of gift. Once it fails, that part that fails will go out of the will. Got it? Will go out of the will. Therefore, the inheritance will follow the intestate situation. This is the rule of intestacy. You look at Cap 73, which we'll talk about lecture 5. Now, with this failure of non-residual gift and the failure of part of the residual gift, or the failure of all of the residual gift, will give us different legal implications. That will be of significance when we shall examine Rule 19 in terms of application for grant, the priority for grant entitlement when someone died with a will. You die with a will. People may die with a will or may die without a will. So if people die with a will, all right, then you say, is it probate or is it LA with will annex? Both situations, people die with a will. The thing is, if died with a will, then what happened to the part that goes outside the will? So that brings us to the partial intestacy that we have briefly mentioned before. If this is partial intestacy, that will become kind of complicated in two senses. Number one, if this is partial intestacy, the will is still valid. If the will is still valid, depending on who a person is applying for the grant, if this is executor, we got probate. If this is someone other than the executor, we got LA with will annex. But the thing to consider is, well, partial intestacy, the priority is still governed by Rule 19. Yet, it is ironic because we say Cap 73, which is IEO, which is Interstate Estates Ordinance, it is this ordinance that says partial interstate is legally also defined as interstate. So the irony goes like this. You apply for a grant, you look at Rule 19, which is testate. And yet when it comes to inheritance, then this partial interstate will have to be dealt with under the rule of intestacy, which also covers a partly testate situation. This is where in our actual practice where the difficulty may arise, because in section 5 we shall briefly mention about this partial intestate, and then there is something which I will introduce through class about this rule, which is called the hodgepodge rule, which is called the rule against double benefit. You cannot get benefit so much so that it becomes kind of uneven distribution. So this is a rule against double benefit. It's very complicated, but as we move along, then you know. Okay? So all this stems from what we understand about doctrine of lapse, effect on the gift. Get it? If you are able to get this theory fully understood, the rest will become much, much easier in terms of our understanding. Now, last time we started by saying that in terms of lapse, meaning the gift losing the effect, there are 4 types, right? Do you remember? 4 types of lapse. Very briefly, we have mentioned it. Can anyone raise an example? The first type, you? Any type? 4 types of lapse. A beneficiary kills, close. Someone kills someone, but then none of them is the testator, nor the beneficiary. Then you die yourself. Okay, but in a context of inheritance, in a will, some related party kills someone else. Then there is a doctrine of lapse. Legal implication, very simple. Any beneficiary who kills the testator, or any beneficiary who kills the deceased, will be affected by the rule of forfeiture. So, losing the benefit. This is one example. Good. The other one? Anybody else? Sorry? Divorce. Divorce. Day 1, will. Day 2, divorce. So some of the gift will be of no effect. Some of the gift will be of no effect. Meaning the gift to the spouse will lose its effect, shall lapse by virtue of the day 2 divorce. Okay, second example. Number 3. 2 more. Look at the looks. Then look at me. And give me the answer. Don't go home. Don't go home and study. Study now. Don't waste your time. Go home and sleep. Beneficiary die before the deceased. Right? Yes. Number 3. So any beneficiary die before the deceased, this is general rule, will lose the benefit. Will lose the benefit. Cannot inherit. Now, we're not talking about the exception yet, but even still on this point, there is something that we should note. In the testate situation, this beneficiary died before the deceased. A lot of time is extended, given an extended meaning, by way of a conditional gift. Instead of predeceased, they extended to say unless the beneficiary shall survive me for usually 1 month or 28 days. Okay, so it's either 28 or 30. So to make sure that not only they deceased died, if beneficiary died before the deceased, the normal doctrine of lapse, predeceased of beneficiary, shall apply. But in a testate situation, because the will said, well, I give everything to my wife, conditional upon her surviving the testator for 28 days. So this is an extended meaning in a testate situation on this predeceased concept, making this survival extended by the period stipulated under the will. Okay, 3 examples. Okay, the 4th one. What is the 4th one? Yes. Yes. Okay, good. So, if a beneficiary, it should be the other way around. If the attesting witness is a beneficiary, then the legal consequence is the will is valid, but the gift to the attesting witness will not. So the doctrine of lapse also applies. So all we have said so far on these 4 different types will tell us the legal consequence on the doctrine of lapse. Of the 3 examples, only the one on the forfeiture rule that will apply also to the intestate situation. All the other 3 applies only to the testate situation. Okay? So rule of forfeiture also applies to testate. But then the unique thing is rule of forfeiture will also apply to intestate. So that's the thing that I want you to remember. Now, having got these 4 concepts well remembered by you, then let's look at the exceptions. Now, beneficiary died before the testator. This first one must be remembered carefully, because there is possible confusion between testate and intestate. Now, just a while ago, I told the class that of the 4 types of lapses, only the rule of forfeiture shall apply also to intestate. This is what I said. Now, on this beneficiary died before testator, there is also something very similar between testate and intestate situation. That's why we have to be very careful. On lapse, the exception is section 23. The exception is section 23. So, if I make a will, usually it goes like this in examination. I make a will. I make a gift to my son. And then I make a gift to my brother. Okay, I give each of them, let's say $50,000. In order to test our understanding on how this doctrine of lapse shall apply and how the exception shall apply. So you have to be very careful. Again, I do it again. I make a will. Testator make a gift, firstly, $50,000 to the son. Secondly, another $50,000 to not a son, but a brother, meaning the brother of the testator. Let's say both of them die before the testator. You will be asked to discuss on the legal consequence. This is usually how you will be examined. Now, here the first exception under section 23, Will's ordinance, is applied. This exception applies only to a gift by the testator to his issue. Issue shall mean all the lineal descendants. I may give it to my son, I may give it to my grandson or great-grandson. Great-grandson grandson, son, all three of them are issue. All three of them are lineal descendants of a deceased, in this case a testator. But I make a gift of 50,000 to my brother. My brother is not my issue. So, if they both die before the testator, you will need to explain to what extent Section 23 shall apply. This is where the difficult point. First of all, the gift to the brother is not issue. It's not issue. So the gift shall lapse in any event. This is the first stance. Secondly, my gift to my son died before the testator, general rule, lapse. Exception, he is my issue, he is my son, then it may or may not be saved by Section 23. The condition is, number one, he needs to be my issue. Number two, on my death, there are remoter issue of my deceased son who survived the testator. That is the important point. So, if I die, testator die, son die before, no remoter issue, this shall lapse. Section 23 apply in a way, but not sufficient. Apply because he is my son. But then he died without leaving his own children. Therefore, Section 23 cannot help. Consequence, the gift shall lapse. So in a situation like this, gift to the son without remoter issue shall lapse and not saved by Section 23. The only way in order to save it is not whether my son has made or has not made any will. Now this is the area where students get confused most of the time. Then they'll say, oh yeah, Section 23 applied, the gift is not lapsed. Since my son died, with a will, everything should go to, in his will, he gives everything to his wife. So my gift, under my will, because he is my son, therefore the exception kicks in, and therefore the gift to him is still valid, but because he died with a will, in his will he gives everything to his wife, and therefore my gift should pass on to his wife. This will be wrong. This will be wrong. Regardless of whether my son died with or without the will, regardless of whether my son in a will gives to whom, these are all irrelevant. The question that you have to explain is, well, according to the facts, when Mr. Wong, you are a testator, you die, your son already predeceased. At the date when Mr. Wong, you die, is there any remote issue of your predeceased son who also survived? If the answer is yes, then the gift shall not lapse, but rather the gift shall go, bypassing your son, but go to the one who saved the gift from lapse. In this example, the grandchildren. It's only those grandchildren who survive at my death. So that is the thing that I want you to draw attention, pay attention to. Something very similar will happen when we talk about intestate. That's why I say it's confusing. Give to divorced spouse, the only exception is Section 15. General rule, give to former spouse, lapse. Exception, meaning the gift shall not lapse if there is a contrary intention as disclosed or as can be found in the will. So that is an important point. Not from any other circumstances, but from the will itself. If I make a will, I say I give everything to my wife, regardless of whether there is a subsequent divorce. Then from the will itself, you can clearly see the contrary intention. The legal consequence, therefore, well, Section 15 as an exception comes in, and therefore, despite the day to divorce, the gift to the former spouse, is still valid. There is no lapse, because one can find a contrary intention in the will. The third one, give to attesting witnesses. Now this, the exception is, the general rule, lapse. Gift remains valid. The will remains valid. The gift is not. If the exception comes in, then the gift to the attesting witness will also be valid. Under this exception, the exception says, if we do not include the signature of the attesting witness, then the will still be valid with two or more attesting witnesses. So therefore, in order to save the gift from lapse, in practice, in situation like this, we will ask more attesting witnesses to have their signature in the will. So sometimes you will find in the will, how come Mr. Wong, there are 3 attesting witnesses or 4 attesting witnesses? That is the whole reason. Well, because your client will be very stubborn. He want to make sure that his son is a witness, okay? To make sure that he understands, he give him only very little. But then, in order to make the will valid, in order to make the gift to the son also valid, then he should arrange for 2 other witnesses. Sometimes, for the same reason, you will find a will with 4 or more attesting witnesses. Because the exception, the law says, if we ignore those gifts to the attesting witness, those lapse gifts to the attesting witness, there are still sufficient attesting witnesses. So if you have 4 attesting witnesses, there are 2 separate gifts to 2 of the attesting witnesses, then we can still argue, well, without A and B, we still have C and D. Therefore, the will remains valid. So this is how the exception comes in. Now, as a matter of caution, we will have to be very careful, because what we are talking about is Section 5, subsection 1. You cannot say, hey, Mr. Wong, following your argument, can I do it like this? I turn this into a Section 5, subsection 2 informal will. In other words, I now stand up and argue that the will remains valid without any attesting witnesses. This may appear to be one argument to save the validity of the will. But as we have already said a while ago, the validity of the will is not affected by the gift to any of the attesting witnesses. The gift the will be valid in any event. It's only here that we talk about the lapse of gift. So even if you can argue that this is a section 5 of section 2 informal will, which can be valid without any attesting witnesses, nevertheless, the will's ordinance still comes in on this lapse gift issue. That is to say, some of the attesting witnesses, only 2 for instance, then if they are given a gift, then the gift given to them shall lapse. So you cannot argue and say, oh, this is something which does not require attesting witnesses. It doesn't come in like this. You cannot have, the best of both worlds. So this, we have to be careful. Forfeiture, the thing to mention is, for murder, no discretion. For murder, people convicted of murder, beneficiary convicted of murder, will not be entitled to inherit in any event. The court has no discretion. Must apply this lapse strictly. But then, if the one who killed the deceased is convicted of a lesser charge, that is to say, something other than murder, then under this rule, the court has a discretion. So it's up to the judge to consider. Someone convicted of manslaughter or some other lesser offense causing death, then the court will consider a particular situation in order to determine whether there is any justification for the discretion to be exercised, so that the one causing the decease will still be entitled to inherit. Now, so this is something we have to bear in mind. The only situation sometimes one can imagine on the discretion to be considered or exercised, I've never seen one, is where there is an attempt to commit suicide together. Okay? Sometimes people, they love each other so much, but then just like all this soap opera, because they cannot, get the support or the benefit for the other family members, they cannot continue to survive and live together, so they decided they better die. Okay? So let's die together. Okay? Let's have some red wine, and then we can both, have the medicine. Okay? And then we die together. And also more often, okay, let's both of us, have a romance, and then we all jump down and die together. Unfortunately, people may change their mind. Okay? Sometimes they change their mind. And sometimes, because all this may not always happen as planned. Okay, you both jump together, and then one died and one survived. So life is really ironic. So if you survive, and then you become seriously disabled, you cannot even commit further suicide. So how are you going to support yourself? Then the argument will come in under his rule of against forfeiture. You have poisoned the mind of the deceased to ask her to jump down with you. Without your undue influence, she would not have jumped down. Okay? So that is the argument. Then the court will be given a discretion whose decision may not be the same as the other family members of the deceased. The court will then say, all right, In this particular case, I exercise my discretion. I may be convicted, but of a lesser offense. And then the court will say that you are so unfortunate already, and you are now a complete disabled person. Well, still get some money out of the deceased estate in order to survive you, support you for the rest of your life. So that's why the court is given a discretion for this rule against forfeiture. So these are things for you to remember. Abatement we talked about already, redemption. Effect of gift. By examination time, I shall refresh your memory again on this one. Whether this is non-residual failure of gift or failure of residual gift. Let me mention about this. The last point on this slide is on distribution of estate. The thing that I like to introduce you as a brief outline is there is a distinction between insolvent estate and solvent estate. Insolvent estate, asset not sufficient to pay all the debts. This is insolvent. Beneficiary, whether under the will or under the rule of intestacy or intessus, Cap 73, they will have no claim. If they have no claim, then they have no right to enforce against the further estate administration, and the same also applies to grant application. No priority. Testate situation may be an exception if there is a will appointing someone as the executor. That this perhaps is the only exception, because executor does not depend on any gift or any right of inheritance. It's just appointment to do the job. Then theoretically, then on insolvent estate, you can still apply for probate if you like. But other than that, in any other capacity, whether testate or intestate, there is no more beneficial interest that one can rely on. And therefore, the talk about priority depending on the right of inheritance shall disappear, and therefore no right to apply. So it's an entirely different rule when it comes to insolvent estate. In Hong Kong, it's a little bit different in the situation because it's capable of changes. Capable of changes because as time flies, then particularly when the deceased has some landed property. For the past history of Hong Kong, land or landed property tend to increase in value very rapidly. Very rapidly. So by the time when a deceased died, insolvent estate, but when it comes to, let's say, 10 years, then increase of the landed property increase in value. So initially it was insolvent estate. Subsequently, there was enough money to pay all the debts, and therefore insolvent estate by then changed to solvent estate. You can argue once the whole thing becomes solvent, then the normal priority will come in. So this is something we have to bear in mind. Whether in future this will happen, I don't know. But then this is what happened in the past. Okay. Then now, this is on preparing and drafting will. We'll talk about how will is to be drafted. This is one area you guys will have to be extremely careful. particularly for those of you who are working in legal firm, a law firm. Now, the fact that you have studied this module, the fact that you know how to get online on precedent will, make it very probable that you guys will actually be the key personnel for the preparation of the will. Your boss will receive instruction from normally the major family member. My mom is dying. My dad is dying. So can you go to QM and then sign a will, let's say this afternoon. He's about to die this evening. It always happens. Always happens. Once your boss receives the instruction, immediately he'll say, "Hey John, come in. I want a will urgently." Then you go on and prepare. Your boss will not give you any chance to think about it. And you have to rely on what you have picked up from me, which I'll give it to you, in order to prepare a will which is valid. You have to be very careful, very disciplined. Otherwise, you would or you may commit a serious mistake which you can never forgive yourself nor your boss. He should have killed you. Because making a will is something that you can never regret, you know. The major family member asks his best lawyer to prepare a will, and how dare you fail it. You betray the whole family, you know. All this, when somebody is to die, you want to get a share. You want to say, this is something prepared according to the wish of the person who is about to die. So all this in practice is a very complicated thing. You don't have the chance to say no. You have to do it because you are so good. You know, you pass this examination. But mind you, no matter what we discuss, the rule of thumb is always make your will as simple as possible. As simple as possible. Don't say that Mr. Wong has taught me all these fancy skills, all these, you know, common courses. I'm going to get from a president in order to get a will, usually about a few pages. This is something which will happen because if, let's say one of these days, you will proceed further and get an LLB and you study and get the professional qualification in any one of the 3 universities in Hong Kong to get an LLB and proceed further, you will be given this is what we call the boilerplate, the precedent, very fancy, and I can show you to all the authorities so that you can make a very comprehensive will in order to show how good you are. But please remember, when it comes to making of a will, it's not how fancy you can word them. It's how good you can make it valid, particularly when you don't have time to think or to lose. So therefore, make it as simple as possible. I'll just show you the case on the judgment a while ago. In that case, I prepare only 1-page will. A 1-page will. Usually with a will, at least you will have 2 pages. Isn't it? Yes or no? You've got all this fancy stuff. and then you go after the second page linked together because of the attestation clause so lengthy, and then at the back page there will be 3 pages altogether. And all this will make things very complicated. And then I make this 1-page will which is in Chinese. In Chinese. So it's very simple and straightforward. And yet when it comes to a fight, a competition on inheritance, they will still go after you. So that was the experience which I've got. I got the will in passing, maybe in 2008. And then I end up having a judgment which is 2021. So it's a matter of discipline that I ask you guys to be extremely careful. Don't make it fancy. Make it as short as possible. So this is the rule of thumb. And there are other things that you consider which we'll examine, such as the various expansion of the power on administration of estate. This is where the problem will come. Because from precedents you can easily add powers like do you need the unanimous approval for advancement, the power to buy back the matrimonial home, which is expanded in order to suit the convenience of the surviving spouse, and so on and so forth. All this, when it comes to urgent situation, you should be brave enough to say no. The reason is, while the law sometimes may provide for all this, you will have to be careful in providing for these sentences in the will. And the more important thing is, because you're trying to capture the legal point which is allowed by the law, that means you will have to spend more time to make sure that the deceased testator in his final hours are able to understand this very difficult legal concept, which is best to be avoided. The easiest way is trying to provide in a will when you can just simply say, I divided my residual estate into a number of parts. For instance, 10 parts or 100 parts. Make it round figure. And then depending on the liking or the apparent liking of the deceased on certain members and the disliking on other family members, then you vary the ratio, you vary the number of parts. That is the best. So I give 8 parts out of the 10 to my wife. I give 1 part to my son. I give 1 part to my daughter. That is one way. And then you say, okay, now this is a will. A married man got a family of 3 and then got 2 other girlfriends. What can you do? One way you can consider is to expand the numbers. From 10, you expand them into 12. Okay? You can 8 to your wife, 1 to your son, 1 to your daughter, and then the other part, 1 to the first girlfriend and another 1 to the second girlfriend. The same analogy shall apply also to charity. Okay? The deceased is so annoyed with the family members, so you may decide to cut it, let's say 10 parts. I give 1 part to my wife, I give one part to my son, and I give one part to my daughter, and then I give 7 parts to the community chest. That is one option, because in so doing, it's only the proportion which may be arguable. But in so doing, in your will, at least you are able to reflect that you remember the test that we talk about, Banks and Goodfellow. You know how much money you have, and you know who are the claims of beneficiaries. You give one share to your son and one share to your wife. That means the testator has not lose sight of the person who is likely to have a claim. Except that now he's about to die, he knows that he needs to do more charity. So 7 out of 10. Or to make it more drastic, okay? You can make a 97, and then out of 100, and then the last 3 shares, one to your wife, one to the son, and one to the daughter. That might a bit out of character, but all this, if you can convince and seek instruction from the testator, is just to show that in the will itself, you are able to say that the testator did not lose sight of the persons who are likely to have a claim. The first test of Banks and Goodfellow, do you know the nature of the act? Sometimes, how can you show to the world that this is a will, that the testator understand that this is a will? Therefore, sometimes you can see people like to make a will, and in the top there's a title that says 遺囑 as a title. Now, there's no law that requires you to give a title like this, but these 2 words by itself, if it is in Chinese, will certainly have caught the mind of the testator, that he or she knows that this is a will which is to take effect when he or she dies. So this is a very good illustration on item, on the first component that we have to satisfy on Banks and Goodfellow. And then the scope of the assets. Now, this sometimes is troublesome. Be very careful. Because if you are asked to say, I want to give my flat to my son, and I want to give something else to my daughter, there will be argument that if the value is not roughly the same, then people who got a lesser share will say, no, that doesn't know that the landed property is so expensive. Okay, you give me the flat, and then you give to my brother, let's say all the cash in bank. So certainly by the time he dies, cash in bank may increase substantially or may decrease substantially. I got a flat which is $5 million, and then cash in bank in Hang Seng Bank now only up to $5. So it becomes an uneven gift. The testator didn't know that things are changing. That will be an easy attack as to the understanding on the kind of the asset that he has in mind, the scope of asset. All this, even on the size of the assets, can be reduced or remove the unnecessary argument against you as a will preparer by using the example which I've just cited. Well, whether I have 10 million or 10 billion, that doesn't really matter. I give 7 out of 10 to my wife, 1 to my son, 1 to my daughter. So whether the size would increase or decrease for a time when I die doesn't really matter. And even if the testator was out of her mind, it's still a matter of number of parts. You don't have to remember, do you know that how much money you have? So this is one area that you can sort of, avoid all this problem. I remember in the will, in the judgment that I've just shown to you, is a one-page Chinese will. I mentioned, in order to show that he understands how much he has, my instruction was that, well, he has got assets of 1 billion. Okay, 1 billion. So in the will, I said, yeah, I appreciate that I got assets of 1 billion, and then she goes on to make the various distribution. In fact, she gave everything to her second sister, or elder sister, and give nothing to the younger sister. And then I give it to the testatrix. Testatrix come back to me with a minor correction. Instead of 10, she corrected me to say 40. So in other words, she explained to me when I actually got to see her, she said, Mr. Wong, my property now is not 10 billion, as you said. In fact, I got 40 billion. That's a lot of money, of course. But then that shows the kind of things that in her mind. In order to face the subsequent attack now on the validity of the will, to show whether the old lady knew the extent of his property. I got the changes that she told me. Instead of 10, just change the number of 110 into 40. But that shows that she understands the extent and the scope of the property. For the rest of your life, you will be the main person drafting the will. Using the example that I've shown you, always be careful, simple. Like when I say I use numerical numbers, 10 billion, 10 billion, or 40 billion, 40. That's easier to look at. So things as simple as possible. Okay? Why don't we take a break now and we'll start with the formal lecture.